If you can show me in the law that I can, then let's talk. That means you got to get it.
In writing.
No. Go through the actual, this is the Code of Criminal Procedure. In here, there are certain provisions with regard to non-disclosures, who is eligible for them. You have to read it, you got to digest it. You definitely are not, I don't think you're, I just can't, number,
Yes,
by
that is
chance.
right.
Okay. Okay, what is it?
It is 22
Okay,
24
okay.
574.
Ms. Wickenhofer, in the flesh.
I know, right? We're famous, by the way. Over 30K people watch it. Anyways, it doesn't matter. I have to read off my phone, so I apologize, but
It's okay.
it says, Your Honor, I was convicted of driving while intoxicated in this court on October 14, 2019, under cause number 222. You already got it. I was sentenced to 4 days in jail, and I have completed that sentence, including paying all fines, costs, and restitutions. I am here today because I meet all the legal requirements under the Texas law for non-disclosure of this conviction. Specifically, number one, my conviction was for DWI with a blood alcohol level below 0.15, which actually was 0.11. I specifically remember. I was not placed on community supervision for this offense. This offense did not involve an accident with another person. I finished my sentence over 5 years ago. I have not been convicted or placed on deferred adjudication for any other crime except for minor traffic violations. This conviction from 6 years ago is still hurting my reputation and my ability to grow in my career. I deeply regret my actions and have learned from my mistakes. Since then, I have worked hard to turn my life around, and I am asking for a second chance. Granting this non-disclosure will allow me to fully move forward, both personally and professionally. It would help me reach my potential and improve my future. Thank you.
Absolutely. So, I don't think I can. Show me where you think I can, but non-disclosures are traditionally for people who take deferreds, complete the deferreds, and are eligible to have it sealed. Expunctions are for those that meet the requirements where if a case gets dismissed, they can have it expunged. Here, when you plead guilty, I don't think you're eligible for either. And the thing about it, I can't give you legal advice. I can't tell you how to look this, how to look that. But if you have a piece, or if you can show me the law that says I can give you a non-disclosure, and I can tell you, Ms. Wickenhofer, I love it, and I've told you this before, I love it when people try to better themselves, right? If I can, I will, because I'm always about trying to make someone's life better, right?
Yes, sir.
But I have to follow law. I can't just say, okay, I can't just rubber stamp and do it just for the sake of doing it. There has to be a law, because if not, they appeal it and I'll get overturned.
Yeah, I think it was the points I said, because I was under a certain amount of alcohol in my system.
That doesn't, what matters is the ultimate result in the case. Did you plead guilty? Did you do a probation? Did you do a deferred? I think that the legislature even now made deferreds available for certain types of DWIs so that people don't get convictions, right? But, and we never do them, right? But you can, right? And it's surprising that no people do deferreds on DWIs.
Traditionally in Harris County, Judge, we don't even offer deferreds on DWIs.
But if theoretically, if you go without an agreed recommendation, we could, and I think that we may have. I don't remember, but
so they don't grant deferred here then in Harris County.
No, you can. You
have to pay more money, so it sounds like.
No, it's not about money. It's about, there are other options that are better.
Okay.
For some, so.
I think that's probably why I didn't do it, because they didn't give me the option to.
We always do, though. Every single case. I talk to every single person that comes up here, and I make sure, hey, look, you're making a lifetime decision. Are you sure that you want to do this? Because it's not Target. You can't return it once you do it.
Yeah.
I literally, every person I scrutinize, micromanage. That's why we're still here. It's 1:10 when most judges are gone by
I
now, right?
understand. Yeah, people tell me.
But I really care about everybody that rolls here and I want everybody to get the great result, and I don't know what was happening in your life at the time when this happened. Why did it end up like this? Was there something other, did you have other charges elsewhere? If you can show me in the law that I can, then let's talk. That means you gotta get it,
In writing.
no. Go through the actual, this is the Code of Criminal Procedure. In here, there are certain provisions with regard to non-disclosures, who is eligible for them. You have to read it, you gotta digest it. You definitely are not, I don't think I can't give you legal advice, right?
Yeah, I understand. Something we could do, but I don't know. I just want something to be done. I just don't know what can be done. It doesn't sound like anything, which really sucks for me, but.
Nice. Yeah, and the thing is that I even tell people that, within a certain amount of time, if you get buyer's remorse, within 30 days of doing something, we've really reopened cases for people who get buyer's remorse, but here, the case is 5 years old. I have no jurisdiction, even if I wanted to reopen it, to do something, I can't. The only advice.
Any service I can do, like any extra thing I can do?
What I would do is really go to a lawyer. You're gonna have to spend a little bit of money. Go to a lawyer and fine tooth comb non-disclosure law
Okay.
and see, is there an out? Is there this? Is there that?
Mm-hmm. Just ask questions. Okay.
You may have to hire a lawyer to really dig into it to see what you can do. Okay. But I can't give you legal advice. I can't sit there and comb the code with you to see, is there a provision that would get it? Because there's so many little nuances here and there. Right. I mean, even so much as a 0.15 or above or 0.15 or below, how long it'll suspend your license versus there's just so many little nuances. I'm so sorry.
That's okay. What was that book called again?
The Code of Criminal Procedure.
Okay. All right.
So,
Thank you.
Google Code of Criminal Procedure, Texas non-disclosure, and even if you do that in Google, you'll have so many other lawyers' sites. Read through all those.
Okay.
But I don't think that I can. Once you plead guilty, that's it. That's why I caution everybody, when you take the easy way out, when you do something like this, it's a lifetime thing.
Yeah, I understand. Thank you.
Sorry.
And here's the cold reality most people don't realize. Even if a non-disclosure were granted, law enforcement, government agencies, and licensing boards would still see this DWI. So the relief she's fighting for wouldn't fully erase the past. It would only hide it from public background checks. This moment perfectly explains why judges say pleading guilty is a lifetime decision.
Vic, what's the last name on the gentleman?
Wilkins, page 21.
You're Christopher Wilkins.
Yes, sir.
Wilkins, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On May 20th, 2024, officers were dispatched to the address of defendant's stepfather. The complainant was stated he confronted his son about missing items. The complainant was told the defendant to get ready for rehab. The complainant was noticed his jazz bass guitar was missing and observed his neighbor's cameras, which showed his son to leave the house. The total value of that guitar was $480. That was all I have on this one, Your Honor.
Do we know he did it?
Your Honor, it stated that there was.
So dad is saying there are several items missing from the house.
Yes, Your Honor, including a guitar.
A bass guitar.
Bass guitar.
Anything else?
Yes.
Does dad call the cops on his own son?
Oh, Your Honor, it was.
Stop.
My fault.
Stop. Don't
Fault.
say a word. Are you losing? So why talk?
I'm not sure how they the police were contacted here, Your Honor. It just says that they met and spoke with the complainant.
Another report written like it's just going through a drive-through.
So, Your Honor, the only thing I would say is, she's facing the VIMs. The defendant had initially declined any of the allegations, but later told his mother that one of the items that was stolen, which was a bicycle, was later stolen from the defendant when he left it at his store.
And here he's charged with a base car. What the? I have a pet lizard named George. Really? Mr. Wilkins, I'm going to find that there's no probable cause to go forward in your case. This life is a very short life. And when you start racking up convictions, it really hoses you. It's really hard enough as it is as a black man in today's society. And when you start racking up convictions, especially theft convictions where you branded a thief, do you think it helps? No, it doesn't. Get into school, get some knowledge, get a degree, find something to do, and make a lot of money. That's what life's about. Not ending up in court with a theft charge. You know what I mean? If you have a drug problem, address it before it becomes a real issue and it takes a hold and grabs you by the boo-boo. You know what I mean? Plenty of people in there. We don't need any more. Please. What happened with upstairs?
We're gonna go on a 15-month defer down here, and everything's gonna get resolved.
Are you going to dismiss that one in exchange for this one?
And no, and
the weed? Got it. Okay. You know, there's not many times that you're going to be afforded this kind of deal where they're going to dismiss a felony in exchange for your plea on a misdemeanor. So I would be very, very careful. If all this stems from self-control or usage of dope or alcohol, I mean, really, there's some people when they drink, they become the life of the party. They're happy, they're fun to be with, they crack jokes. And then there's some people that turn into the devil incarnate. If that's you, then this should be a wake-up call. If it's not, what's it going to take, 25? You're charged with two very serious offenses. You have the assault down here, you've got the assault upstairs. They're going to dismiss that felony assault in exchange for this one. You're entering into a very serious probation where it's a 15-month deferred. This is a type of agreement where if you complete it successfully, you do not end up with a conviction on your record, but it's not dismissed. If you complete it, there's no conviction, but you can't tell people it was dismissed. It's not dismissed. Just you complete it successfully, you don't end up with a conviction on your record. You need to understand that there's still an affirmative finding of family violence. You pick up another one of these, you're looking at a third-degree felony, another 2 to 10 at the penitentiary. Do you understand? You can also never own a gun or ammunition as a result of this plea bargain agreement as well. Do you understand? Is this what you want to do? You give up nearly every right known to man by entering into this agreement saying, look, I'm going to make it, and if I don't, you can put me in jail for an entire year. That's the agreement that you're entering into now. So for you to complete this successfully, you must do a batter's intervention prevention program. This is a tough one. This is a class that you have to attend once a week for 18 weeks. If you miss it, they're going to kick you out of the program. If you get kicked out, we issue a warrant for your arrest. We'll have a hearing here to see if you violated. No drugs, no alcohol. You will be tested like crazy to ensure that you're not using. You must also do a TRAS. This is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them as well. 20 hours of community service, $100 one-time donation to the family violence provider, no threatening or harassing abusive contact with Mr. Cockrell. Do you have children? I think that in lieu of community service, I would like to do a parenting class. And if she does a parenting class, then I'll waive the community service. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you're stuck with this until you complete it successfully or it gets revoked. Do you understand? I like to reward people. You know, I like to encourage people to do well. And what I normally do is if you do well in this agreement, If you don't test positive for dope or alcohol, you get all your classes done and you're nice to everybody, I'll take you off in half the time.
Okay.
So you can be done in half the time. If most, just be nice. Don't pick up any new cases and don't use. You understand? Is this what you want to do? How do you plead to the offense of assault of a family member? Guilty or not guilty? I'm not going to find you guilty now, Miss Loyola. I'm going to wait essentially for 15 months to see if you're able to comply with this. As part of this agreement, the possession of marijuana will be dismissed and your other case upstairs will also be dismissed as well. Do you get child support for the children or? Okay, cut her fees. It's never about the money. I don't care about the money. I care about you doing what you say you're going to do and showing up and doing it on time. The worst possible thing you can do is either pick up a new case or abscond. You just take off. That's an instant warrant in this case. You understand? So if you ever have any problems, come back. We can always work through it. We can talk about it, but just doing nothing and taking off, it's the worst thing that can possibly happen. All right, so I'll follow the agreement, send it you to everything. Good luck to you, ma'am. Good morning, Ms. Blewett. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with complaining witness one, who stated that he, the defendant, and the other complaining witness were in a polyamorous relationship. The first complaining witness stated that the defendant had sent numerous texts and calls and showed up unannounced at the residence. The complaining witness, the first complaining witness stated the defendant struck him in the face while the defendant had a phone causing pain and a tooth to become loose. The second complaining witness stated the defendant arrived at the residence, and while complaining witness one was trying to calm down the situation, the defendant struck complaining witness one in the face, and in the process of breaking the fight, the second complaining witness was struck in the shoulder, causing pain.
But we only have the assault on the gentleman, correct?
The assault's only on the, I'm sorry,
The gentleman,
I believe so,
you
yeah.
only got one count.
Yes, Your Honor.
Okay, Ms. Blewett, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you, there's a protective order that has been issued in this case. You need to get to know it. If you do something to violate the protective order, the state can and probably will file additional charges against you. Do you understand?
Yes, sir.
I'm ordering you not to have any contact with this person and not to be in possession of any weapons. If you violate this, I will revoke the bond, put you in jail. No more PR bonds for you, man. Do you have the ability to hire a lawyer?
Court appointed lawyer. Court appointed.
Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. I'll take a look to see if you qualify. I need to know everything about you, how much money you have in the bank, how much money you work, and I'll take a look if you qualify. I'll have you sign a receipt. Victoria, Deputy Miranda is going to give an application, and I'll have you take your seat in the jury box. Do not leave until you sign our bond condition. Bond conditions. Can you file no contact, no weapons, please?
Yes, Your Honor. So no contact, no weapons?
Yeah. Good morning, Mr. Delaney. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, a law enforcement officer responded to a trespass at a gas station known for being a drug trafficking hotspot. Law enforcement officers witnessed surveillance footage of the defendant making multiple hand-to-hand transactions and throw something in his vehicle when the law enforcement officers originally approached the gas station. The law enforcement officers detained the defendant and approached the vehicle and witnessed 2 sacks of marijuana on the passenger floorboard area in plain view. A probable cause search was carried out, and the officers identified the 2 sacks on the passenger floorboard as marijuana. The total weight of marijuana was 76.37 grams.
Mr. Delaney, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to go back to this gas station. Do you understand? I'm also ordering you now not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand?
Good.
No more slinging. Do you understand? What do you do with yourself these days? Do you have a full-time job?
I'm doing application right now. I have an interview tomorrow.
Good. I'm bringing you back in 2 weeks and I want to see that you have a full-time job. Do you understand? If you come back and you've done nothing, it's not going to go well. And I'm telling you, I'm going to drug test you within the next 50 days. If I find that you continue to use, it's not going to go well for you. You understand? All right. Did you want to apply for a court-appointed lawyer? Okay, Deputy Miranda's going to give you an application. I'll have you sign a receipt in Victoria. You will then meet with Fleischer for your bond conditions. I'm also ordering you not to be in possession of weapons as well. Do you understand? Okay, come on. What, you said 15?
15 is GD.
What's your?
15 is GD.
Yeah, but hey, 15?
Oh, I'm sorry. Phillips is on page 15.
Yeah, okay. You're, Mr. Phillips, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, on September 1st, 2023, a law enforcement officer responded to failure to stop and give information call in Harris County, Texas. The law enforcement officer made contact with the complaining witness, who stated that she was pulling into a parking lot of a corner food store and observed the defendant's vehicle reverse into her direction quickly. The vehicle then rammed into the rear driver's side of the complaining witness's motor vehicle. The defendant's vehicle then quickly shifted into drive and fled the parking lot. The complaining witness took a photo of the rear of the defendant's motor vehicle after the accident and provided the license plate to the law enforcement officer. Law enforcement officer found the motor vehicle registered to an address less than a mile away and traveled to that address and made contact with the defendant. The defendant stated he was at the food store with bursting out of the parking lot and struck the complaining witness. The defendant stated he fled without providing information because he did not have a driver's license. The defendant was identified with his Texas ID.
So, you run his license, please, just to make sure.
Yes, Your Honor. I'm just not showing the driver's license numbers, so I'm not sure if he is part of the license since then, but we don't have it in our system.
If you do not have a license, do not drive. I don't care what's going on in your life. I don't care that you have to go to work. I don't care that a baby needs to go to the hospital. I don't care there's a burning building and you need to save 50 kittens. If you don't have a license and liability insurance, do not drive. You will be signing an affidavit with me today. This is the promise that you're going to make, that you're not going to drive. You cannot justify getting into a car for any reason. And if you do, you can be facing an additional 6 months in jail on a contempt charge. Every time you drive, it's an offense in and of itself. Do you understand? What do you do with yourself these days, Mr. Phillips?
I work and take care of my little sisters. My dad had recently passed away.
You have a full-time job?
Yes, sir.
Did you graduate from high school?
Yes, sir.
Okay. Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to qualify. I need you to fill out an application. I'll take a look to see if you qualify. I need to know everything about you. Do not drive, Mr. Phillips. If you want to drive, go get a license, get insurance, show me that you have these, and then we can talk. But until that point, don't do it. There's going to be HE double hockey sticks to pay if you do. You understand? All right, come on.
Robert Shelby and the holdover, you wanted to, Bill Strategy had to leave, you wanted to.
You mind? Yeah, please. So I'd like to do PC. I just want to know, because it's a DWI second, but there's also an evading. If you could just give me a brief rendition of what happened, please.
Yes, sir.
When he comes out.
Yes, sir.
Morning, Mr. Shelby.
Morning.
So your lawyer was here before I got here, and he had to leave to go to a funeral. So I wasn't able at that time to do conditions, but I want to put bond conditions on you because you now stand charged with a driving while intoxicated, second offense. You're also charged with evading arrest in a motor vehicle, which that one is a third-degree felony. You're facing up to a minimum of 2 years, a maximum of 10 years in prison into Texas in the TDCJ. So can you please give us, you have the right to remain silent. Anything you say can or will be used against you, sir.
On April 3rd, 2025, in Harris County, Texas, an officer observed the defendant's vehicle traveling 117 miles an hour using a rear antenna radar. The officer observed the defendant weave between vehicles in an unsafe manner, and a traffic stop was attempted. The defendant passed an available exit with no indication of stopping and ran a red light. After a 20-minute chase, officers stopped the defendant's vehicle using a pit maneuver. The officers moved the scene to a parking lot, and upon contact with the defendant, the officer noticed glossy eyes and bloodshot eyes with an odor of alcoholic beverage. The defendant was identified by his Texas driver's license, and standardized field sobriety tests were conducted. The officers witnessed 4 to 6 clues on the HGN, failed to keep balance on the walk and turn. The defendant refused the one-leg stand. The officer is a drug recognition expert and observed signs of drug intoxication. The SC was read and the defendant refused. A blood warrant was executed and blood was collected.
Can you run his license, please? Seek his license.
Yeah, he doesn't know. So,
At 117 miles an hour, Mr. Shelby, I am now taking away your privilege to drive. I am appointing you, Mr. Pruitt, here in the interest of justice now because your lawyer's gone to a funeral. But I'm putting these bond conditions on you now. And I want you to know that I will do everything in my power to protect my community at all costs. Do you understand?
Yes.
You are not allowed to drive.
Yes.
At all. You will be signing an affidavit. This is a promise that you're going to make to me that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a monitor on your ankle so I know that you're not consuming. You will be tested for drugs and alcohol. If I find that you're using, likewise, I will revoke your bond and put you in jail. If you have a problem with drugs or alcohol, now is the time to address it. Because if you don't, and I see that it becomes a problem while you're on bond, I will address it for you, and I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I am now sending notice to DPS that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Every officer in this state will know that if you're pulled over and you don't have an interlock on whatever car you're driving, they will arrest you and put you in jail. And that is a violation of your bond condition here. Do you understand?
Yes.
You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. As it stands now, I'm taking away your privilege to drive, so you're not allowed to drive. You will get a device on your ankle so that we know that you're not consuming.
Yes, sir.
So he's not required to get the interlock unless you rescind that order for him not to drive?
Correct. You will get a STRAM device within 3 days. Within 3 days of your release, you will be required to get a STRAM device. And if you fail to do it, then your bond is going to be revoked. As it stands now, you haven't made bond on the DWI in your felony case. That's why you're still being held now.
That's a SCRAM device.
It's a device that goes on your ankle so that we detect through perspiration whether you
Yeah,
are consuming.
drugs.
All right. I just wanted to bring you out to give you notice of the condition that we're placing forth on you now. All right? Okay. All right. So we need him to sign this and then sign with Fleischer and then.
Thank you.
All right. Thank you so much, Carl. I appreciate it. You sure you want to do this?
As we talked about probation, we talked about, the
You have
different
no
choices they have.
convictions. You have no as far as I see, no convictions. Now, after today, you're going to end up with a conviction on your record. From now on, you're looking at 90 days in jail for any new cases that you pick up, you know?
The choice is, you can get the defer, you can get the probation that we talked about, but you decided to do the time.
When you plead guilty to something, it goes on your record and it stays there for the rest of your life. You can never take it off. And it will affect you when you try to get a job, try to buy a house, try to get a car, a loan for something, try to get an apartment. So that's what I'm saying. I mean, you're old enough to know that.
No, I was lost when you was like 90 days at the.
No,
I was lost because.
No, what I'm saying, you pick up anything else in the future from now on, it's a minimum of 90 days if you take this deal, because they can enhance your punishment to a minimum of 90 days in the future.
You're not getting that as a time served deal. The judge
I'm
just
served
wants-
here, but what I'm saying is, you don't want to defer to try to keep it off? You just,
Sir, if you look at the computer, I've been to TDCJ before. It don't matter. It don't matter.
That's,
I'm just gonna be
That's like
honest
this.
with you. It don't
I
matter.
don't see, I only get access to Harris County because I can't get them to give me access to anything else anyway.
I
So,
understand, but I can tell you, and I
Okay.
at my time, I done did my lesson. So if time served, I don't have to go to jail. I don't have to look over my shoulder. that's fine with me. I walk a straight line. That just was unfortunate happened with my property.
You're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. Like I said, this is going to go on your record. It'll be there for the rest of your life. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, that's it.
I understand.
This is what you want to do.
Yes, sir.
How do you plead to the office?
I plead guilty.
I'm going to find you guilty. I'll follow it. Good luck to you, Mr. Pack.
Give me
Take
1
care.
second to get you this piece of paper, go downstairs so you don't have to go court cost.
All right.
I'll be with you.
I think the offense date was March the 30th, sir. So a little more recent.
No more.
Sure.
I'm going to test you 50 days from today.
Sure.
If I find that you continue to use, it's not going to go well for you. Do you understand?
Sure.
Do you have a job?
No, not at the moment.
It's time. It's time for you to start working and being productive. When you have too much time on your hands, you become self-destructive. That's what we don't want. I don't want you to pick up a 6th case or 7th case now within the next, that's it. I'm going to bring you back in 2.5 to 3 weeks and I want to see what you have done to get a job. If you've done nothing, you understand.
Yeah.
All right, good luck.
And he did let me know he has enrolled in HCC for the summer session of college.
That would be great. That's great. But if you're taking 6 hours, you got to do something else as well. If you're taking a full load, then great. The more schooling you do, the more money you're going to make in this life. Knowledge is power, and with knowledge, you get money. That's what this life is about.
This is the emotional breaking point. She's not arguing the facts anymore. She's arguing fairness. From a legal standpoint, the judge is correct. Once you plead guilty, the door closes. But from a human standpoint, you can feel the frustration. This is a classic courtroom clash. Legal finality versus personal regret. Be honest. If you trusted your lawyer and later found out it hurt your future, who should bear that responsibility? You or the system?
Judge, I was in court 4 and just sitting there for a while too.
Don't worry about it. You're good. We're glad that you made it. Did Stradley come here today?
Yes, he reset it.
He already left?
Huh?
He already left?
Yeah, he already left.
Okay. Because we need to do conditions. It's a second. It's a DWI second. We need to do conditions. And I know, but I still want to put conditions. He's going to bond out, I would imagine, right? But I'm putting conditions first. I want to get conditions so we get a guardian interlock and now. Yeah, see. Yeah, I need to, I want to put conditions on him, you know? And if you can't, say that we can give him someone in the interest for now, just for purposes of conditions, okay? It's okay. Tom, hear you.
Tom, I'm gonna send you an email on this one. I think we've got it worked out.
All right,
Just let me know when you're ready, okay? Hi.
thank you, Judge. I just wait here in the link.
Yes, ma'am. Good morning.
Good morning, Judge. I'm here on an off-topic matter. Is that okay?
Yes, okay, of course. What's your cause number?
There's 2 and, Judge, hang on.
I forgot my eyeballs too.
There's a DWI, and that's cause number 2556097. And there's a tampering.
This on Mr. Hernandez?
Yes, sir.
Are you representing him on both?
I am, and Judge, we just realized, I'm sorry, my staff, I just filed the notice of appearance on the tampering. We didn't realize he had 2.
We have you connected.
Okay.
It looks like he has an ice hole.
Well, yes and no, that's why we're in front of you. So he apparently posted, maybe the PR bond here. I got him from the jail. He went to immigration. April 2nd, posted a bond there. But we've got 2 warrants. I believe these warrants are holding him. And so didn't know if, I think Harris County maybe has 10 days. I don't know for sure. They have a certain number of
What
days.
happens is that we don't get notice, or I guess we didn't realize that he's in immigration. We assume that he's out, he's gone on the lam.
Right.
So
And they didn't
we
have
issued a
a
warrant.
order to tell you, Judge, so.
So it's He's made bond on the immigration case?
Yes.
Okay,
Yes.
so I can reinstate these bonds now,
Okay,
but as soon as he gets out, he needs to come here immediately for bond
of
conditions.
course, okay.
So we need to set a day.
What's the case number?
You ready?
Yeah.
It's 255-6097. There's two. I'll reinstate it now, but if he's not here by the next setting, let him know that I'm gonna end up revoking him because he needs to come here for bond conditions. I guess just pick if you want like maybe a week or so.
Okay.
Yeah.
Thank you.
Yes, ma'am.
Appreciate it.
Of course. Did you get the cause number?
Yes.
There's two.
Anthony Hernandez?
Yeah, please, reinstate both.
Yes, sir.
Yeah.
Tom. I filed with dismissal in that case. I filed with dismissal.
Are you talking to me?
Yes, I filed with dismissal on when?
I appreciate it. Thank you, sir.
I'll sign it as soon as I get it too, okay?
Thank you, Judge.
All right.
Thank you,
take care.
counsel.
But if the case is older than 150 days old,
Yeah, where are we headed?
we're waiting on the RIP call and the 911 call. I believe the state has sent an escalated request.
There, we've requested the 911 call twice, Your Honor. I'm not sure why it's not in yet. I've just requested if we could just have one more sentence while I try and reach out and hound somebody to get the 911 in. It is,
Subpoena them to come to court. That's what I would do, so give them 10 days, subpoena them to come to court. And then if they provide it to you, then great. If not, then, but if they can't get you just the 911, then that's as simple as possible, okay?
yes, Your Honor.
So a 10-day discovery hearing. Yes, ma'am.
Thank you, Your Honor.
Sure.
We're good, man. Approach.
Yeah.
How you doing?
Hi, Mr. Allen. How are you? What's new?
I've got Serato on your docket, copy for the, like you see.
Thanks. You too. What's new?
Yeah, she's got a bond violation. She failed to show up to a drug screen, she was at work. She did test yesterday, she tested negative.
Great.
Yes, sir.
Okay. Is she here now?
She is here.
I'm bringing her.
Yes, ma'am. Yes, sir.
Come up, ma'am.
And I'm gonna reach out to this man and the message.
Sure.
Oh, so we can go this up. I want to see
I'm glad that you tested negative. Good job. Don't miss again, please. Okay, if it happens again, I'm gonna issue a warrant, okay? All right, good luck. Thank you. Thank you. Take care. Always. You said Miller?
Miller, Jeremy Miller.
Jail or bond?
On bond, wait,
Say it again?
he's waived today, but on.
Okay. Sixth threat, 156 days. It's an old
I know,
case.
Your Honor, we've been trying to get in touch with the complainant. But I'll read PC, Your Honor. On November 3rd, 2024, officers were dispatched to 15 over terrorist threat call. Upon arrival, officers met with the complainant, who advised she's employed at Bentown Hospital as a registered nurse. Complainant advised that she was attempting to administer an IV needle in the arm of the defendant when the defendant stated, quote, "Bitch, take the needle out or I will kill you." Complainant said she took her life.
I mean, why?
So I would argue it's a conditional statement, Judge. It's take the needle out or this will happen. I think based on that, it's not an imminent threat, but it's a conditional. If you do this, I will do this. So I don't think it meets the statute for probable cause.
I mean, Your Honor, I would argue that, threatening to kill her in a hospital.
I mean, can that possibly be the law? So anybody can ever, there's a condition, then it's never a terrorist threat,
I would need to look at the case law.
That would be,
I know there's someone with agreements.
let me pull up the statute. Hold on. Let's see.
But I know that the way it's charged, Your Honor, is imminent serious bodily injury or death.
Person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to cause a reaction of any type to his threat, place any person in fear of imminent serious bodily injury. I mean, it doesn't say if it's conditioned that, because the statement is he's saying, I'm gonna what?
He said, quote, "Bitch, take the needle out or I'll kill you."
I mean, show me some kind of case law that says that a condition kills it, and then I'm with you. But I mean, obviously it's a threat, you know?
I can look at
And the needle's in his arm at the time, right?
Correct.
Yeah, I mean, if you show me that a conditional statement it's no good, then I'm with you.
And then I also wanted to ask you about Todd Wallace. That's
I remember Mr. Wallace, how's he doing?
So, Judge, I've not been able to have contact with him. I went by yesterday in person, trying to reach him, and just have not been
You
able to
said
reach him.
it today because you couldn't get in contact with him, right?
Correct.
Okay, so I guess we'll revoke it.
And I spoke with Chief. He's essentially leaving the offer on the table of just an apology letter and a dismissal if he does end up back in custody. So I'll
Because
leave a note
he's-
of that.
I'll leave the first setting to your honor if he does come back.
Did you put that in the notes?
I already put it in there, your
Put a
honor.
specific note for
I'm gonna
us.
revoke it now just because you have no contact. If he should show up, then we'll talk.
The exact note I have here under proposed, defendant is going to bond forfeit. When he comes back into custody, I will keep the apology letter offer open for 1
Yeah,
second.
we just don't know what circumstances are going.
Yeah, I understand.
So, I'll do 1501. Or, sorry, 2501. Hey, so 2501 on Wallace. And I'm not gonna do a BO.
All right, pause here. This is where things start to go off the rails. What the judge is saying is legally important. Non-disclosure is usually tied to deferred adjudication, not convictions. This woman believes time has healed the case, but in law, how the case ended matters more than how long ago it happened.
You're on bond for 2 assaults, and now you've picked up a new case. Can I explain myself? We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On October 15th, 2024, officers were assisting with a stranded motorist disabled in Harris County, Texas, when a witness ran up to the officer and stated that he had been shot at. Witness fell on the ground and the officers observed defendant running across the street. Witness pointed out the defendant and stated defendant was the one who shot him.
What?
Shot at him.
He's charged with an evading arrest and an aggravated assault with a deadly weapon?
Sure, Judge. I can look further into the offense report.
Your Honor,
But
on this case, initially, yes, that's what the complainant said, but upon further investigation, the officer could not locate the weapon. And also, he was unsure of whether, based on the offense report, whether the defendant was the one who shot based on location of the complainant, as well as the fact that he couldn't observe the weapon upon retracing the steps of the defendant.
Don't we have shot spotters out there now anyways? I mean, you know, it would be interesting to see where this location is, see if there's an actual shot spotter out there. If there is, let's pull the records. You know, it's not rocket science, okay?
So the defendant then began running in the officer's direction. Officers marked patrol vehicle was blocking the lanes with lights activated. Officer yelled at D to stop.
I'm the defendant.
You are the defendant.
Yelled at the defendant to stop and identified himself as police. Defendant turned around and began to run away from the officer. Officer gave chase and yelled again to the defendant, IDing himself and asking for the defendant to stop, which the defendant refused, looking back and continued running. Approximate length of chase was 0.6 miles.
Okay. Mr. Richardson, I'm going to find that there's probable cause to go forward with your evading arrest. You have been given multiple bonds. I asked you to do one thing while you were on bond for both of those assault cases. Do you remember?
Stay clean.
And stay out of trouble.
Stay out of trouble. I was shot at.
And now you picked up a new case. I'm revoking your bond. He goes with you.
Revoking my bond.
Mm-hmm.
I was shot.
We're going to look further into the facts.
Please. Are you DeJuan Fairley? Mr. Fairley, you're charged with assault of a family member. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Any witness and the defendant are dating and they have a child. On October 14th, 2024, any witness was driving while the defendant was a passenger and their son was in the rear seat. Defendant began questioning complaining witness because he thought she was cheating, which prompted an argument. Defendant began putting his hands in complaining witness's face, impairing complainant's ability to see the road. Complainant brought the vehicle to an immediate stop. Defendant then began grabbing her left shoulder. While defendant was grabbing her shoulder, complaining witness turned and bit defendant on his hand in an attempt to get defendant to release her. Defendant then punched complainant with a closed fist in the face, causing pain.
All right, Mr. Fairley, I'm going to find that there's probable cause to go forward with the case. Do we know whether she wants to have contact with them?
I believe she does want contact, Judge. It looks like someone from DVD did the rip.
How do you have that belief?
Someone from our domestic
Zach?
violence division called her, and she said she doesn't want to move forward. So she does want contact with the defendant.
Any other priors that you see?
No criminal history, Judge.
Okay, Mr. Fairley, I'm ordering you as a condition of your bond not to have any threatening or harassing contact with this witness. If I find that you do, I'm going to put you in jail. You will not get any more PR bonds. Do you understand?
Sir.
So I don't know what kind of relationship you have with this person, but if you're someone who's constantly going to fight with this person, be careful. Because remember, it's not what you think as far as threatening or harassing, it's how she perceives. So can conduct in and of itself violate this order? It absolutely can. If I go like this, is that threatening or harassing? It is. And it can land you in jail in a moment's notice. Do you understand?
Sir.
We're going to reset your case to give you time to hire a lawyer. So I will have you come up here. The other thing you need to understand is there's a protective order that is in place. I would get to know it because if you violate the protective order, the state can and will file additional charges against you. And then it gets ugly really quick. Do you understand? I will have you come up here. Well, we're going to have you sign a court order for you not to have any threatening or harassing contact. I'm also prohibiting you from having any weapons as well. No guns, knife, nothing. I'll have you sign a receipt and we'll get you out of here to hire a lawyer. All right? Do not leave until you sign our bond conditions. Otherwise, I'll issue a warrant. Please. Is it DeTwain Johnson? DeTwain. Mr. Johnson, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you soon.
On October 16th, 2024, officers conducted a traffic stop in Harris County, Texas on a silver Buick bearing a Texas temp tag with no return to a motor vehicle, no light, and not sure what that means. But he had a temp tag that did not return to a vehicle and no lights in the back. So the defendant exited from the driver's side of the motor vehicle, leaving the vehicle on and walked towards the patrol motor vehicle quickly. Defendant attempted to walk back towards the driver's side to turn off the motor vehicle. Officers stopped defendant before he opened the door. Defendant stated the firearm was inside the vehicle. Officers opened the driver's side door and observed a Glock in plain view, unholstered, and in the driver's side door panel.
Find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
No, sir, I have an ID, a state ID.
You're not allowed to drive. I'm making that a condition of your bond, and you will be signing an affidavit with me today promising you're not going to drive. If you get a Texas driver license and liability insurance, I will let you drive. But until that point, if I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months and a $500 fine every time you drive. Do you understand?
I had insurance on my car though. They
Don't have a license. You need a license, a Texas driver's license.
Oh, yes, sir.
Until you have a license, you can't drive. I'm glad that you have insurance because that's really one of the most important parts. Because if you get into an accident and create $50,000 in damage, if you don't have insurance, they're going to come after you and make you pay the 50 grand.
Yes, sir.
Have insurance, and if you get into an accident, they'll even give you a lawyer to represent you. But you still need a license. If you get a license, come back and show me, and then I'll take this off. But until that point, don't. We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive, not be in possession of any weapons, and after that, we'll let you go. What do you do for a living?
I work with landscaping and mulching.
And how much money do you make a month?
Oh, my father. Work for like 25. It'd be like 25.
A month?
It's not that much, you know.
This was 2,500 is not bad. I mean, who do you live with? Where? Do you live by yourself in the apartment or who with?
Just me.
Do you have any children?
Yes, sir. I have a daughter.
Where's the kid now? Do you provide support for the child? I'll have you fill out an application. I'll take a look at it to see whether you qualify. I need to know everything about you, what kind of car you have, how much money you have in the bank.
I don't have a bank account there.
Oh, you don't put all zeros, because if you do that, I'm gonna send it right back to you. I need to know everything about you, monetary, financial, everything. Do you understand? We'll have you come up here, swear to this, and then they'll give you an application, fill it out, and I'll take a look, okay?
Judge, we also have a Spanish arraignment.
Hi, caramba, la bamba. Come on, man.
Page 10, Gutierrez.
Come on, Luis. Okay, yeah. Is it page what, 10?
10.
Israel Gutierrez.
Yes.
Mr. Gutierrez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On October 15th, 2024, officers observed defendant's motor vehicle exit a parking lot and drive into the main roadway very suddenly with rapid acceleration. Officers saw that the vehicle had a defective license plate light and expired registration. After officers stopped the vehicle and made contact with the defendant, officers observed the defendant to be wearing no shirt, had unbuttoned pants on, a strong odor of alcohol in his breath, and glassy eyes. Defendant was leaning on his car for support when asked to step out. Defendant admitted to drinking. SFSTs were conducted. 6 out of 6 HGN. 4 out of 8 walk and turn. 2 out of 4 one-leg stand. DICs were read, but breath was refused, and a blood warrant was signed and executed.
Any prejudice?
No, Judge.
Mr. Gutierrez, I'm going to find that there's probable cause to go forward to the case. Do you have a valid Texas driver license? Are you a United States citizen? Are you in this country with or without permission? You're a citizen?
Yes.
Do you have liability insurance in your name? Okay, as long as you have both, you can continue to drive. I am ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or drugs, I'm going to put you in jail. You will not get any more PR bonds. Do you understand? Can you run his license for me, please? We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria real quick, sign a reset. You'll get with pre-trial for your bond conditions. And after that, you'll be free to go. When you come back, please have a lawyer. And I'm going to tell you this now, that don't take your time waiting for a lawyer, because you're only hurting yourself. There's a lot of timing requirements with the DUI, and it could really hurt you if you just sit there and wait. Okay? That's okay. Please. Okay. Great.
Right this way.
Okay, Robert, let's go.
Coach, ready, coach? COJ. Sí, señor, no, señor.
Are you Coach Tambariz Franklin Abraham?
Yes, sir.
Yes, sir.
Charged with driving while intoxicated, you're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you have served. You need to understand, after today, this DWI will go on your record. If you were ever pulled over, an officer will see a prior DWI. If you smell like alcohol or dope, they're going to arrest you, put you in jail. What we're doing today, from now on, you're facing a minimum of 90 days in jail. So if you're not in this country with permission and you go to jail for that kind of time, I can all but guarantee an immigration detainment. So if I were you, I would never get in a car, even if you've had a sip of alcohol. Do you understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen or a possible immigration consequence, you can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you plead guilty, you cannot change this. It will go on your record and you can never take it off. Is this what you want to do?
Yes.
Is it true or untrue that you had a 0.15 or above?
Yes.
Okay, so true to the enhancement. All right, sir. How do you plead, guilty or not guilty?
Guilty.
I will find you guilty, sentence you to 3 days in jail. I will give you credit for the 2 days that you've done. I'm going to suspend your license for 90 days. Do not drive. Your license is now suspended. Do you understand? If you drive, you're going to be right back over here, and it's not going to go well for you. All right,
Judge,
good luck.
he makes between $500 and $600 a week, supports an elderly mother. He doesn't have much money. Can you waive the state traffic fine, Judge, on that? He doesn't have any savings, no bonds, no stocks.
I want you to understand something, Mr. Cloverstumbridge, that your lawyer is asking me to waive the fines and fees for you. Do that as a courtesy. Now, I'm now taking away around 500 to about $4,000 in fines and fees. It will not happen again. You come back here with the DUI, it's going to be at least $6,000 to $7,000 that you will be responsible for. So, out there, back here with another DUI, it's really going to go sideways for you. Do you understand?
Yes, sir.
Okay, all right.
Thank you very much, Judge. Thank you.
It's okay. Ricardo, what do you got real quick?
Judge, if I can approach real fast. Oh.
Just- Okay, what's the name?
Freddie Ruiz, Judge?
Freddie Ruiz.
Freddie Ruiz? Yes.
So Ruiz, you're charged with racing on a highway. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 15th, 2024, officers observed two motor vehicles traveling at a high rate of speed on the 3100 block of Blalock Road in Harris County, Texas. Officers observed both motor vehicles line up at a red light and both motor vehicles traveling at a high rate of speed side by side. Officers caught up with motor vehicles and initiated traffic stop. Officer made contact with the defendant. Defendant stated he was going home from work. The other driver swerved into his lane like he was attempting to strike the defendant's vehicle.
What?
And then the defendant decided to do the same thing to the other vehicle.
So they're like demolition derby?
That's kind of what it sounds like, Judge. And they both started traveling at a high rate of speed after that.
What does a high rate of speed mean?
¿Qué significa velocidad excesiva?
I'm gonna check the offense report and see if we have the exact speed.
And he makes an admission that they're racing?
He makes the admission that he was doing the same thing to the other vehicle that the other vehicle did, where the other vehicle was attempting to hit it.
And do we have a co-defendant as well?
I don't see one listed. Judge.
Stephen, I'm gonna bring him in 5 minutes.
That's fine. I just wanted to go check on they're still okay.
Percolating, you know? No.
It doesn't look like the officer provided the exact speed that they got to in the offense report or in the DIMS. He just says high rate.
Racing again? Other than the demolition derby?
So the officer observed them, right, driving together, and then I believe he pulled the defendant over, and then had to call in a Spanish-speaking unit. And And then, so the defendant stated that he was traveling home from work, and just that the defendant swerved into his lane trying to strike his vehicle, or sorry, not the defendant, the other driver swerved into his lane trying to strike his vehicle. And then the defendant decided to do the same thing.
I get it, and it could be a deadly conduct, but where's the race? Read it again. I mean, maybe I missed it, but.
No lo escuché.
So, yeah, the officers observed them traveling at a high rate of speed. Again, we don't know what speed. He watched them both line up at a red light and then going side by side at a high rate of speed. And
Different.
that's what the officer.
See it like in a competitive manner,
Right.
then that's racing.
So that's what the officer observed, and then once he pulled the defendant over, that's where the officer learned that the other driver, according to the defendant, had tried to hit the defendant, and the defendant tried to hit him back.
They're at a red light. They both take off at the same time at a high rate of speed.
Right, and the officer pulls over the defendant's car.
All right, Mr. Ruiz, I'm gonna find that there's probable cause to go forward with your case. This is the second time that we have an incident like this with you, so I am taking away your privilege to drive. You are not allowed to drive at all, and you will be signing an affidavit with me today, promising me that you're not gonna drive. If I find that you do, I will have a contempt of court hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Do not drive. Do you understand?
Yes, sir.
You will be facing a lot of time in jail if you do. Heed my warning, because every time you come back, I'm going to pull your record to see if you're driving or not. You have a lawyer. They will take care of you. I will waive your appearance, but it is your responsibility to stay in touch with them. And they will tell you when you have to come back to court. If they tell me they can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You pick up a new case or start acting a fool in the free world, we will not give you any more PR bonds. Do you understand, Mr. Ruiz? Okay, all right.
Just quickly, this is the second time he's been.
He has a prior evading arrest in a motor vehicle, and now we have a racing case. I don't want him in a car. That's it.
Understand, Judge.
That way.
Just can you turn the bond conditions up?
Yeah, Ricardo. Ms. Hernandez,
Yes, Hernandez. How are you?
you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please don't say anything.
On August 18th, 2023, the defendant issued a check for $1,577 as a payment for vehicle registration. The bank returned the check saying that there were insufficient funds. Complaining witnesses provided a copy of the demand letter sent to the defendant, no response.
Got it. All right, I'm going to find that there's probable cause to go forward with the case. You need a lawyer to represent you in this case. This is a theft by check and it can have dire consequences on your, going forward. We're going to reset your case to give you time to hire a lawyer. So I'm not going to put any conditions on your bond. Just be careful. Don't pick up any new cases. We'll just have you sign a reset and we'll get you out of here. When you come back, please have a lawyer. Okay? Please.
Hola, caballero, buenos días. Pase aquí, por favor. Son declaraciones, ¿cierto? Hágase aquí, hermanito. Venga, hermanito, buenos días. Párese aquí en el centro. Solamente miren los jueces. Solamente miren el juez, perdón, y le contestan nada más en español, señores. ¿Cuál es su apellido? Martínez. ¿Martínez? ¿Y el tuyo? Gutiérrez. Gutiérrez.
And who's the other guy?
Para adelante.
Where's Martinez?
I will. Martínez.
I don't see it.
Going to use it, or neither. Okay. Be glad. Is it under Martinez? Okay. Well, you can always call me for help. Professional, very. No.
All right, gentlemen, good morning.
Yes.
Both of you guys are charged with criminal offenses. Both of you guys have worked out agreements to take care of your cases today. I want you to understand, both of you guys will now end up with convictions on your record. If you ever come into contact with police again and you have the smell of alcohol, you have the smell of dope, and they come into contact with you, they're going to look at your record.